Thanks very much, Cameron. I want to first begin this rebuttal by reminding everyone that the reason why we are arguing about precedents that are not about criminal immunity and the reasons we are arguing about consequentialist policy preferences is because the text and the structure and the history of the Constitution are dead set against recognizing immunity from criminal prosecution for the president. I think we can lose sight of that. My able opponents here have made a very strong case, I think a better one than the Chief Justice made, for presidential immunity here. But it all resided in the extension of prior precedent into a context in which that precedent was not decided and is not similar to, and consequentialist analysis of what would be good policy going forward. Arguably, good policy that would support the separation of powers, but not necessary policy to support the separation of powers. So let me address a couple of things. First, United States versus, Nixon versus Fitzgerald. Here's a statement from Justice Berger's concurrence, which gave the court its 5-4 majority in that case. You may not have known that the case was a very close case, one of the early cases in which the court began to split 5-4 fairly frequently. Here's what Justice Berger says in defense of the decision. The enormous range and impact of presidential decisions far beyond that of any one member of Congress inescapably means that many persons will consider themselves aggrieved by such acts. Absent absolute immunity from civil claims for damages, not even from civil claims for injunctive relief, every person who feels aggrieved would feel free to bring a suit for damages, and any suit, especially those that proceed on the merits, would involve some judicial questioning of presidential acts. Such scrutiny of day-to-day decisions of the executive branch would be bound to occur if civil damages actions were made available to private individuals. Notice how much the consequentialist analysis in Nixon versus Fitzgerald relies on the fact of a very reasonable expectation of a flood of claims against the president for merely doing things that citizens who can establish standing disagree with. Right? This is a very plausible fear. It's borne out in the cases under Bivens versus 6 unknown named agents, which is what the Nixon case was, Bivens claim. And so if it's plausible in that context, I think we should ask whether it's plausible in the context to which it's being extended. And with the long history since Bivens was enacted, or since Bivens was decided, of Bivens claims and a long history of other implied claims in the civil context, standing against 0 prosecutions of a former president until just now, I would think that we would pause before we extend the precedent on the former landscape to the precedent in our current landscape. I would think that we would consider extending Nixon into the criminal context to be not supported. None of the civil immunity cases mention criminal immunity at all. The only place criminal immunity is actually recognized is under the Speech and Debate Clause, which is an explicit provision of the U.S. Constitution. We don't need to engage in consequentialist policy analysis to get to criminal immunity. The Constitution lays it out explicitly. It does not do that for the president. So we need to make sure that we remember that. Secondly, there was a couple of good points here in the consequentialist analysis. So now that I've made that point, I'll play on the turf of our opponents. One of the points was that one of the bad consequences that could happen as a result of not recognizing immunity is a sort of carousel of retaliation from president to president to president to president. And of course, that is a plausible fear given what President Trump has said, or former President Trump has said about his former opponent and his former rival. I do acknowledge that. But criminal prosecutions have to surmount some pretty significant hurdles. Indictment by a jury, a grand jury, selected from one's peers for probable cause, presented evidence, who make a judgment that a prosecution can go forward. The Fourth Amendment, the Fifth Amendment, the Sixth Amendment, all of these are extremely important precedents. In addition to that, the sort of, and if you'll pardon my characterization here, extravagant examples of criminalizing the pardon power, for example, can be handled under our ordinary separation of powers jurisprudence. We have United States versus Klein, which is a post-Civil War case in which the Congress tried to interfere with the effect of a presidential pardon, President Lincoln's pardons of vast majorities of former Confederates, in a case where one of those former Confederates sought to get his cotton back, or to get paid for the cotton that the Union had taken from him. And in that case, the Supreme Court held that Congress cannot pass a law that directly interferes with the pardon power of the president, that directs the court to apply the pardon power other than the way that it was granted to the president. Separation of powers jurisprudence is enough of a tool to protect the president against those sorts of incursions. We do not need something as full in scope as an absolute immunity or even a presumptive immunity from prosecution to do that job for us. Thank you.